Good evening. Welcome in Daily UPSC Editorial audio program. It's basic really. Times of India. Falling short the Hindu. Now the full editorial. It's basic really the terms of India. Delhi Service Bill may have cleared Parliament, but it will still have to pass the basic structure test in Supreme Court. Delhi Services Bill may have cleared Parliament, but it has to pass the basic structure test in Supreme Court. The debate in Rajya Sabha on Monday over the Government of National Capital Territory of Delhi Amendment Bill witnessed an unusual intervention. Ex-CJI Ranjan Gogoi, while making a case for the bill, questioned the basic structure doctrine that limits the legislature's power to change core feature of the constitution. It has been noted that this was at odds with his view on the subject when he was a Supreme Court judge. It is 50 years since the Keshwanand Bharati verdict introduced the basic structure. The pushback, however, continues. Basic structure is best understood as a non-negotiable aspect of the checks and balances in the parliamentary democracy. It is balancing instrument that works by drawing boundaries. Invocation of basic structure is never abstract. For example, a constitutional bench used it in a verdict delivered in May on the division of powers between Government of India and Delhi government. The verdict said that democracy and federalism are a part of the basic structure of the constitution. How does it work in in practice? According to the constitutional bench, a triple chain of accountability is the framework that gives effect to democracy. The chain comprises bureaucracy, a government, and a legislature, which emerges after a popular mandate. Consequently, the case went in Delhi government's favor. Political parties have not always been accepting of limits on Parliament's power to amend the constitution. In the 1971 general election, 2 years before the Keswanand Bharti case, quit a few parties in their manifestos wanted changes that ensured that Parliament's power to alter the constitution wasn't subject to judicial restraint. However, over time, all major political parties have been supportive of the basic structure doctrine. Over 5 decades, it is essentially has been accepted by all stakeholders. But there are and will be skeptics. Some of it stems from judicial overreach and the fear that the basic structure can become a cover to enable it. However, notwithstanding odd judgments that may trigger such fears, the concept has stood the test of time. The basic structure constraints can also catalyze more insightful parliamentary debates and attempts at bridge building because restraints on exercise of power push parties to create a consensus. Even though Parliament passed the Daily Service Bill, the last word on it has not been said. In July, the Apex Court referred the ordinance which preceded in Delhi Service Bill to a constitutional bench. It remains to be seen if the bill clears the basic structure test. Falling short, the Hindu data protection bill continues to have deficiencies that need cleaning up. The Digital Data Protection Bill 2023 was passed in the Lok Sabha on Monday and will now have to be cleared by the Rajya Sabha. The fresh iteration, which has undergone a few drafts, some staff seems to have incorporated suggestions made to its 2022 versions, although it is not clear what the submissions were as the consultation process was not brought to light by the government. The highlight of the bill is the provision that personal data of an individual, the data principal, may be processed by an entity or a person. The data fiduciary of the lawful purpose only after the consent of the data principal or for certain legitimate uses. These uses are situations where such data may be processed without obtaining the data principal's consent, such as by government agencies for providing licenses, welfare benefits, permits, and services. This bill includes an obligations on the part of the data fiduciary to notify the data principal and the Data Protection Board (DPB) to be established by the government to adjudicate on compliance or not with the bill. If there is a personal data breach, there are other obligations defined for the data fiduciary as well. But one issue with the bill is that it does not include the need for informing data principals about third parties with whom the data could be shared or duration of storage. Too much leeway is provided to agencies of the state in the form of exemptions. The Sri Krishna Committee's draft bill in 2018 allowed for exemptions to be granted to state institutions from acquiring informed or consent from data principals or to process their data in matters related only to the security of the state, and also called for a law to provide for parliamentary oversight and judicial approval of non-consensual access to personal data. In the 2023 version, the state is empowered to process data through wide-ranging exemptions, and the government is allowed, in effect, to collect information which could be used to mass surveillance in overriding consent to be obtained by the state from the data principal for purposes of providing benefits, subsidies, and licenses. The bill also does away with purpose limitations using the data only for the specified purpose. It seeks to introduce amendments that effectively remove the public interest exemptions to disclosure of personal information under the Right to Information Act, thereby diluting accountability and transparency in the functioning of government officials. The bill also continues to retain a much weaker version of the Regulatory Data Protection Authority envisaged in the 2018 version in the DPV, which will only have adjudicatory and not regulatory powers, and whose members will be appointed by the union government. The bill must be thoroughly discussed, and these discrepancies ironed out in the Rajya Sabha. Thank you.